All right, so I'm here with Jeff Love. Jeff is a real estate attorney handling all types of different things from contracts and litigation to securities work, leases, all kinds of different things. Jeff, welcome.
Thanks for having me, Greg.
Yeah, absolutely. So why don't you tell us a little bit about you, your firm, a little bit about your background, and we'll dig in.
So I'm a dirt junkie, so to speak. Everything with dealing with real estate, from, as you said, kind of buying the property, helping clients develop certain aspects of it, leasing. And I also deal with some related corporate work. So really love to help entrepreneurs and kind of got the real estate bug myself. I thought I was going to actually become a real estate developer out of college. That's what I wanted to do. I liked building things and thought, everything's related to real estate. And I really went to law school to learn, contracts and just have that additional education. And after a couple of years practicing law, I realized, I kind of like this more, helping different clients at different stages, you know, big companies, small companies, and really being kind of behind the scenes. So that's where I am, 13, 14 years later, still helping entrepreneurs, primarily real estate, help grow their businesses.
Yeah, that's awesome. And as you know, I work with people all over the country teaching them how to do real estate development, mentoring them, teaching them other types of real estate investments as well. But I have a lot of people in the real estate development business. So let's talk a little bit about that. I think I've seen some of your stuff out there on YouTube where you have, some videos you've done where you talk about three or four things that everybody needs to look for, in that real estate development process when they're, putting land under contract and the due diligence phase and all that. So you want to talk a little bit about that?
Of course. So I wouldn't even say just development, but anytime, clients are signing contracts, it's to acquire the land, leasing, contractors, everything, you know, we're dealing with a contract whenever you sign your name on that dotted line. And a lot of times clients, we're too busy, or this is simple. I've looked at this 1,000 times. So they're not really paying attention to the details. Um, One of the ones that is the most simple, common sense kind of idea, but I can't tell you how many times it crosses my desk, is make sure you pay attention to these notice provisions in these contracts. Because anytime there's a dispute, it's client misses a deadline to for due diligence, and the deal becomes non-refundable because they didn't look at the notice period when it ended, or they emailed and it had to be sent by overnight courier. Seems, easy. Why are we even talking about that? But I can't tell you how many times we have issues that result from it because it is so simple that it's often overlooked. So make sure whatever contract you're signing, make sure you know how you have to communicate with the other side, not only the dates and the timing, but the method of communication.
Yeah, that's really important. Now, as far as disputes that arise, where do you see the most common areas that disputes arise and why?
I'd say it's the obligations, well, to take a construction contract, for example, and that, most common dispute is going to be over time, because contractor is going to be delayed because client is demanding change orders, or because they're delayed from their subs or their suppliers, and the contract wasn't specific enough about, what is the time, what are the rights of the contractor versus the owner. I want this done as soon as possible. It's costing me overhead. It's costing me, I have a loan, I have deliverables. Contractor wants it done too, but they're reliant on their subs. In one sense, they're kind of the middleman. So a lot of times we'll see disputes in terms of what obligations do I have to do by a certain time frame, and clearly laying out a milestone timetable where these projects have to be met. And if they're not, what are the ramifications and remedies of each of the parties if they're missed?
Yeah, timeline and then cost overruns are a big one as well.
Yeah, they definitely are. And again, 'cause we're talking about now a specific construction contract, but these are kind of universal points because, timing on, real estate acquisition, for example, we could be delayed because we're getting a phase one environmental assessment or a survey because our lender's requiring it, and we run up against that due diligence period. Or we're syndicating the deal and we're going out to investors to raise money, and we're late. So really understanding, what is the ramification kind of remedy if I run up against that due diligence period. I get clients a lot, they're saying, oh, no big deal, I can always cancel. Yes, you can get your money back, but how much money have you spent on due diligence? Do you really want to throw, 10, 15, $20,000 on inspection, survey, attorney's fees, and then have the seller not give you the additional time that you need. So any of these contracts is, really understanding, what do I have to accomplish within the time frame that I'm given. So timing, I think, is the next biggest point. It goes to what I need to get done within a certain amount of time, and make sure you understand that.
Yeah. Now, what about if you're in a situation where, the architect, so the client, the developer, has a set of plans drawn up from an architect. Those are, delivered to the general contractor. The general contractor, builds the project according to plans, but things just don't work out between the contractor, the architect, and things like that. How do you resolve those types of, discrepancies when neither party wants to pay for it and they want to throw it all up back on the developer? So the developer, I've hired the architect, I got a great set of plans, they're sealed, delivered to the contractor. Contractor's looked at the plans, he's based his bid on that, but comes in and something is not working in the field, according to the plan and everything. Who pays for those discrepancies when something like that happens?
That's a tough one. And that's when you're going to get, basically experts to look at your plans versus what the contractor did. And you're the developer, so you're kind of stuck in the middle, but you're the one that didn't do anything wrong. So in that case, we're typically going to go pursue both and say, as we pursue it, one of you guys need to figure it out. We're going to loop in their insurance companies because someone didn't do something according to plan. But that's the most difficult and messy one. And there's never, to give you the lawyer answer, it depends, because did the contractor do something they were, did they take leeway with the plans, or did the architect not properly document something? So that's, you hit the, nail on the head with that one. That's one of the biggest ones, we see, because, it's hard when you kind of get in the field. Things happen.
Yeah,
So
they do. Things happen and numbers don't always add up and doors don't always work where they're supposed to work and things like that. And, I've been in the middle of a lot of those over my career. And, as a developer, it becomes a negotiation. Everybody just kind of takes a, share of that responsibility. But is there a way, which I haven't found yet, to mitigate some of that in the contract documents?
a lot of it, not entirely, because that's, that would be a perfect world. We would never have issues. But one of the wins that we try to do is when we're really looking at the contracts with the architect, with the contractor, making sure that we have not just us, but, having the architect kind of oversee the process and not just give the plans and be done with it, so that we can make sure that any miscommunication, any direction is resolved, because they're still having to work together for the length of the project. And the architect can say, that's not how I drew it. Contractor can say, but in, practically speaking, this isn't going to work. And we can resolve those issues with a small change order, something that doesn't cost a lot, before it gets too far along in the process. So, again, something that sounds simple, but making sure we have proper oversight provisions in these contracts, to make sure that it's not just, a fine line where architect hands it off to contractor and there's no further communication.
Yeah. Now, what about AIA documents, contracts versus, custom drafted contracts for, construction projects? How do you feel about that?
We typically use AI even for, $100 million projects, because the AIA, they've been vetted, they've been used a lot. Both sides should be familiar with it. And they also have the benefit of, it's not a one size fits all. You've got AIA for smaller projects, bigger projects, and the length and the kind of detail of the provisions from, say a investor that's going to, flip a home versus, I'm building a ground up 50-unit apartment building. We have different AIA contracts for that. Custom contracts work as well, but, I'll give you an example. For in California, our regulations through our contractor state license board are so specific. When we start using custom forms, something always gets missed, because, again, I'll use a home improvement contract, because we have a lot of fix and flip type clients, where if you don't have certain language in 12-point font, you can void the contract. You have certain requirements on deposits. So when you start doing custom contracts, a lot of times you'll make edits on this one deal, and then someone will grab that old edited form and make additional edits and additional edits. And eventually you've moved away from what was a a good contract to something that now doesn't meet the statutory requirements. So a lot of times that's why we like to use the AIA, make appropriate edits in that for our contractor clients, and they'll use that form over and over again, and even include an addendum if needed.
Yeah, yeah. There's a lot that goes into contract law because every state's different, and you just even every type of project can be different. Very, very tricky and technical.
Yeah, and it's tough too because you don't want to spend the money every time. You want to kind of have this pre-printed form, which makes your custom document nicer, so you don't have to go into the AIA software. But it also, you got to think at the whole picture, kind of from a 10,000 foot view is typically what I tell the client. We could have your custom form, but is the client, is your client going to be more familiar with this AIA form? Is, if they have an attorney, are they going to be more familiar with it? Is that process going to save you money? Again, not just in construction, but in California for some of our real estate acquisitions, we have a similar kind of pre-printed broker form that a lot of clients from acquisitions leasing they'll use because while it may not be the best form out there, it's the most familiar. So it'll save a lot of time in that negotiation process. And after using it enough, both sides will typically know what's in that form.
Yeah. Now, as far as acquisitions contracts, so what are some of the biggest things other than the time frames and notices and things like that that people should look out for with acquisition contracts? Any pitfalls there that you see commonly?
The biggest one from, I think we talked about, time and notice, what you said, is looking at the representations and warranties. That's typically the biggest negotiated point. The seller, I want to walk away from this property. I'm selling it. I want my money. I want to be done. I want to move on. But buyer, even though I'm doing all my due diligence, it could be a short time frame, 30, 60 days. Do I really know everything about the property? So I want to use those representations as a way to know what the seller knows. So there's a lot of give and take on those. And that's something I really want to pay attention to and make sure as the buyer that I know everything the seller knows through use of those representations. And on the seller side, I really want to limit those to the extent that I can. I want to tell the buyer what I know, but I want to limit claims in the future and say, look, buyer, I'm giving you this free 30, 60-day look. You need to go in there and you need to do your testing, whatever is required, so that you're familiar with the property.
Yeah. Now, as far as a landlord goes, so I'm a developer, I've built a property and I want to start, leasing the spaces out. So what do I need to be thinking about as the owner developer, in my lease contracts with tenants?
You want to make sure, again, you have a good lease form because as the buyer, what we're going to come in and we're going to look at some of these leases and say, do we have the appropriate remedies on, default and breach? Have you given the tenants any special rights? Make sure that you have a good form because we're going to come in and most times we're going to accept that form because a lot of states, you may have tenant protections where you just can't evict a tenant. In California now, even if the lease ends after a year, that tenant's in that property until they leave. Um, so that making sure that lease form is definitely adequate, and making sure you properly document. I really like to see invite clients to, do amendments to lease because a lot of times we'll get into these, mom and pop properties and there's side agreements, there's oral agreements, and as the buyer, that's iffy because I don't know what the agreements are. I want to get in there. I want to rehab the property. And my worst nightmare is coming in and seeing that the tenant has a 5-year lease because the landlord made some side contract. So I'm really going to require tenant estoppel certificates from as many as I can get because I want to know what's in the lease is accurate. And that's the way that I can really know what went on between the tenant and the landlord besides what was written in the actual lease form.
Okay. Talk about what a tenant stop loss certificate is.
So a tenant estoppel certificate is basically asking the tenant to confirm certain facts in their lease. And the name comes from they're stopped from denying it. They can't write something that's true and then later on say it's false. So what you're going to do is typically we use this form, the tenant's going to we're going to ask them to confirm that this is the lease. There's no side agreements. What's the term of the lease? What's the monthly rental? And that I have no extension rights, no rights to buy the property. There's no default by the landlord. And the tenant's going to sign this so that when I close, I know exactly what I'm getting. I can see the lease form, but what has changed since then? And that's what this estoppel certificate does. And if the tenant then tries to say, the landlord gave me a 5-year lease at $100 a month, say, no, you gave me this estoppel certificate. You verified certain information that's true. You can't then go tell me there's some missing agreement. And that really protects me as the buyer because I know what I'm stepping into.
And you would recommend getting that whether there's a lease in place or not?
Yeah, especially if there's not a lease, because then you know what the terms are. What you don't want to do is buy a property and then the tenant says, the landlord, you're in default. They said you were going to make all these improvements. And you then may go back to the seller and say, you didn't tell me about this. This was a misrepresentation. And maybe you have a monetary claim against the seller, but you're stuck with the tenant. And I got a lot of times if we're doing development, we may want to be rehabbing these units. We may want to get the tenants out, and monetary damages versus the seller may not be enough to kind of rectify that wrong. And I'm still stuck with this tenant in this property that I can't get out because they had a 5-year lease that I didn't know about.
Yeah, it's tricky stuff. Now, what about if you're a tenant and you want to lease a space? What are some of the things that you should look out for there?
The biggest one is one, making sure I have a lease form. And a lot of tenants are saying, the lease is it's for the landlord. I don't want it. It's scary. But if it's written correctly, it protects both because when you have a lease form, the landlord can't just raise rent anytime they want. They can't kick you out of the property. So one, I want to make sure I have a lease. I want to make sure that it's very clear in terms of when rent can be raised, how much rent can be raised. If I have a security deposit, what can the landlord use that for? And what are my rights in terms of, you know, repairs, replacements? That's the biggest one we get, kind of friction with landlords and tenants is, okay, my dishwasher broke. Landlord says, okay, you replace it. Tenant says, no, landlord, you're responsible for replacing it. So really outlining the responsibilities, especially for those, bigger appliances, who's responsible for that day-to-day maintenance and replacement of those.
Yeah, and building systems, like if you have a single tenant, triple net lease situation, what are you seeing there in terms of who's responsible for what?
And a lot of times, not just triple net, but there are kind of those outliers, like an HVAC. If we're talking about a retail property, very important. And okay, I as the tenant am responsible for maintenance, but the HVAC, blew out in year 3 of a 5-year lease. As the tenant, I don't want to pay for the whole thing. I'm not going to get the useful life out of it. So making sure if the landlord's not going to be responsible, at least have that cost amortized over the term so that I'm paying my portion over its useful life. And there's a lot of things like that that may kind of sneak by. I'm thinking about triple net, but I'm also not thinking about like an HVAC or how much can these expenses increase, on a year-to-year basis, looking at, and what's excluded versus included from my operating expenses.
Yeah. And then, we hit on a few of those, but let's say I'm a buyer now and I'm buying a building, multi-tenant, single tenant, whatever it is, what are some of the things I'm going to want to, ask for and look out for there in my due diligence process?
One, not just ask for, but one, you're going to want to make sure that you understand the property. So have you done an environmental phase 1? Making sure you have no environmental issues. We can get, certain representations from the seller, but a lot of times if you're going to get a lender, you may be required to get a phase 1. So making sure that I'm okay from an environmental standpoint. Making sure I understand title. A lot of times clients will get this preliminary report and ask my broker, oh, it looks fine. And, there may be old restrictions in CCNRs where I may not be allowed to sell liquor. And I'm going to open a restaurant on this property. I'm going to change the use, and that may completely ruin my business plan. So making sure not just looking at the exceptions, but actually reading or having your advisor read those underlying documents so that you understand the risks. We just had a client buy a large industrial property down in Georgia, and there were 2 old, easements. One was from a railroad about 80 years ago, but it was an easement in gross, meaning it actually applied to the entire property. So if this old utility company that they got this easement from the railroad come back today, they could potentially require the client to tear down the entire building.
Mm.
Likely that never happens, but it's a big risk when you're buying, a $10 million building. So making sure that you work with the title company, and there's a thing called endorsements where you can shift risk to the title company, often for a nominal fee, making sure that you understand all those exceptions on your title policy. And then the final things in kind of your due diligence is, when how about your ordinary building inspection? Even if it's a triple net lease, a lot of times there's exceptions. It might be foundation issues, it might be roof that still fall on you um, to pay upfront cost. Maybe the tenant reimburses you over time, but you may not have it in your budget to spend 50, $100,000 on a new roof. So really kind of getting an idea when you're buying the property, what type of condition it's in.
Yeah, you mentioned on that transaction, the interesting thing about that easement. What about deed restrictions? Can you talk about deed restrictions a little bit? Maybe some of the crazy things you've seen there?
Similar, so those CCNRs, a lot of times those would be, deed restrictions. A lot of times on your deed, you will see exceptions. And where those exceptions are coming from is your title policy. And one could be CCNRs where you can't have, you can't have alcohol on the premises. There are certain setback requirements that you're not expecting. Certain restrictions on, height, especially if this is some type of master plan community, and maybe has a retail portion of it, but you're going to have additional restrictions there. So really looking at CCNRs, deed restrictions, looking at certain easements, making sure that you get them plotted, or you have a survey so that you understand where those easements are, making sure you kind of have proper access to the property. So I'd lump the deed restrictions kind of in with your title policy, because a lot of times they run hand in hand. And make sure when you get that you're actually reading it or having someone go through it, because a lot of times we have clients that, you know, it's a residential property, or it's just CCNRs, it's not a big deal, but they haven't actually read what they say. And that's a lot of times when we run into issues. And not just later on, but a lot of times they'll come to light because you have a lender, and lender brings it up, a week before closing. And then it's a frantic scram to try to get this resolved, because you've already waived contingencies and you need this resolved, or the lender's not going to fund.
Yeah. Cool. So let's switch to real estate syndication. And you do syndication deals all over the country for your clients?
We do.
Okay. So what do those structures look like, and what are the documents that you need for syndication? So I put a property under contract. I've got investors ready to go. So what do I need to do now? What type of entities, and what does that paperwork look like?
So the first thing you want to talk about is kind of the structure, and a lot of times what the entity is. And I get a lot of questions about where should we form it, what type of form should it be, and the two main structures you'll see are an LLC or a limited partnership, because those are two entities that have pass-through taxation. For various reasons, we hardly ever want to hold real estate in a corporation, and we don't want it in our own names because we're not getting that liability protection. So you're going to typically use one of the two, and they both have their pros and cons. So you'll see usually about 50-50 limited partnerships versus LLCs. In terms of where we structure them, you'll hear states like Delaware, Wyoming, Nevada, because they have, maybe better privacy laws, maybe their corporate law has been tested more. But a lot of times it may not make sense if I'm buying a property in Texas to have my LLC in Delaware, because I have to qualify to do business in Texas. California is one of the worst, because we may register in Delaware, but now we're paying $800 to register in California as well. So we didn't really get that benefit. So it's a case by case basis where the client is and where the property is. But that's our entity. And as the sponsor, what we're going to do is we're going to have three main documents for our investors. We're going to have an operating agreement or a partnership agreement, and that's for their LLC or a partnership. And that's really our governing document that says what are our rights as the manager or the general partner, what do the investors do, how do we split profits and losses, um, what are the voting rights. That's really the meat and potatoes, so to speak, of the documents. And then we'll have two more. One is called a private placement memorandum, and that's kind of our pitch deck, where we're going to explain to the client, this is the outline of what we're doing. This is kind of our prospectus or our deck. And we're going to have a lot of disclosures in there in terms of risks. Real estate is risky. Our projections are that they're projections. These aren't guarantees. And that document is important because that's how we disclose to investors what the risks are of this investment and really pitch to them, this is what you're investing in, this is what you'll get, so that they understand it. And our last document is usually called a subscription agreement. And that is what it sounds like. An investor is subscribing or purchasing an interest in this company, and they're making certain representations to us as the sponsor of the company that they're not investing for certain tax purposes. We're disclaiming certain rights. It can be short, it could be long. It just depends on, that specific deal. But that's where the investor actually subscribes on and says, I'm committed to purchase a certain amount, a certain interest in this ongoing venture.
Cool. So talk a little bit about series LLCs versus, let's say you want to do multiple deals. Does it make sense to have to use a series LLC versus just individual LLCs?
It can. It's state specific. So, for example, in California, they don't recognize series LLCs. So, if you were going to form that in, say, Texas, and then try to operate in California, you're still going to pay the same fee to have the series. And a lot of times, it avoids confusion from an accounting or legal aspect to just create them separately. But in states, like Texas, where they recognize them, it can save a lot of money because you'll have that parent LLC, and you may have this fund that owns 3 or 4 properties, and you're able to structure it with a series LLC to segregate the individual properties, but you don't have to pay the fees for each one. So in situations like that, it could be very valuable. For the most part, we don't use them that often because the amount that they save can often be eaten up in different ways. But it is a valuable tool to use depending on the state that you're in. So
Yeah.
that is a question you want to ask, just depending on where you are, where the property is.
What about from a liability standpoint? Is there any advantages or disadvantages, to a series LLC from a liability standpoint?
Not necessarily, because each of the children, so to speak, of you have the parent LLC and each of the children, they're all segregated from a liability standpoint. That's the benefit of a series LLC, is each one is still its own separate company, but from a state in kind of franchise tax point of view, they're looking at it as a single entity. So that's really the benefit of them. You get the same benefit by forming, 5 different LLCs, but now I'm paying in California a franchise tax of minimum $800 for each of those LLCs. So you want to look at, where the property is. Does it make sense from that standpoint? And also, am I going to have different investors in all of these companies? Because you can have different operating agreements for the series LLC. But I like them most when I have kind of a real estate fund where I have the same investors, but I buy, 5 separate properties. That's when it can really make sense and start saving money.
Yeah. Cool. Well, awesome. Well, we've covered a lot of ground in a short period of time. So is there anything else that we didn't hit on that you'd like to talk about before we sign off?
I have one, and it's one I learned too from, I invest as well. And it's, again, a lot of the advice sounds simple. I already know that, but I say, make sure you have a good team in place. And what I mean by that is, you don't know what you don't know. So especially when you're starting out, make sure you have a good insurance broker, because that really can alleviate a lot of the risk. Make sure you have a good accountant that understands real estate investing and isn't just your normal, file my tax return, my tax preparer, because they can save a lot of value. Having that real estate broker can help you find off market deals. Your attorney is going to help you alleviate risk. All of these different professionals, and that's just a few, but having that team of professionals in place really helps. You can rely on their experience, and that helps you become a better sponsor, a better investor, because they're going to help fill in those gaps that you don't know and let you focus on the actual deal that you're the expert in.
Yeah. Awesome. So Jeff, how can people find you?
Check me out on our website. It's www.gibbsgiddon.com. Feel free to email me, jlove@gibbsgiddon.com. Always happy to meet new people, answer questions.
Yeah, awesome. Well, I appreciate you taking some time out today and sharing your experience and knowledge. And I look forward to speaking with you again soon.
Thanks, Greg.